Your Honor.
Yes, ma'am.
We're ready when you are.
All right, just 1 second. Mr. Schmidt, who would you like first?
Jacob Hall.
Mr. Hall, go come forward, sir. This is cause number CR 25-28.
And Judge, we were set to proceed with the plea. We've got an agreement with the state. Unfortunately, though, there's some issues that pertain to some of the conditions of probation that I was unclear on. Mr. Hall made me clear on it, that under the circumstances as written, he would be homeless if he took a plea today. So I'd ask to reset him for the Thursday docket, so I can get with Mr. Hartwell as well as some of the individuals named in the conditions.
No objection, Your Honor.
All right, court will reset Mr. Hall to the 20th at 1:30.
Stephen Flores.
All right, this is cause number CR 20-211, State of Texas versus Stephen Flores for pretrial. Go ahead.
That's correct, Judge. I'd ask to set Mr. Flores for a plea.
You want to say March 25th?
Yes, sir.
All right, court sets Mr. Stephen Flores for plea before the court, March 25th at 1:30. Who's next?
Mason Hogue.
Mason Edwin Hogue, CR 24-233 and 234. Show that we're set for docket call.
That's correct, Judge. I've been asked for an additional docket call. Give me a little bit more time to work with the state on Mr. Hogue's case.
Any objection?
No objection, Your Honor. Thank you.
All right, court sets Mr. Hogue for docket call April 8th at 1:30.
Eden Mendez.
Clause number CR 24-239, State of Texas versus Eden Joel Delgado Mendez for docket call.
And Judge, I'm gonna same announcement, ask for an additional docket call, Mr. Mendez. There's some immigration ICE issues that I need to check into and talk to the state about a little bit more.
Any objections?
No objection, Your Honor. Thank you.
All right, the court sets Mr. Mendez for docket call April 8th, 1:30.
Reno Marino.
Reno Santana Moreno, CR 24-242 for docket call.
Same announcement. I'm gonna ask for additional docket call, Mr. Marino.
No objection, Your Honor. Thank you.
Being no objection, docket call is Set again, April 8th, 1:30.
Don Piercefield.
John Daniel Piercefield, CR 22-75 for docket call.
That's correct, Judge. I think we're ready to, resolve Mr. Piercefield asked setting for plea on Thursday.
Thursday this week.
Yes, sir.
All right, court sets Mr. Piercefield for plea on the 20th at 1:30.
Alyssa Schoonover.
CR 22-46. State of Texas versus Melissa Lee Schoonover for pretrial.
That's correct, Judge. We don't have any contested motions at this time as for docket call, sir.
All right, court sets this case for docket call April 8th at 1:30.
That's Lucas Penrod.
Lucas Wayne Penrod, CR 24-281.
I believe we're set for pretrial, Mr. Penrod, Judge. We don't have any contested motions. As for docket call, sir.
All right, court sets Mr. Penrod for docket call April 8th at 1:30.
Michael Williams.
Michael Scott Williams, CR 24-193, docket call.
That's correct, Judge. We received an offer from the state. I've provided the state with some additional information. I think, last week, I asked for another docket call. I have a chance to talk to them about it.
No objection, Your Honor. Thank you.
All right, court will set Mr. Williams for a final docket call on April 8th.
That's all I have in here right now.
Okay.
I'm waiting on Mr. Morgan, hopefully to show up, and then Michael Hegel, but
Okay. Ms. Abraham, is Mr. Stevens there working on his paperwork with this Vial?
No, Your Honor, he said he was running behind.
Okay, all right. Court will
It might be 2:30.
Okay, court will stand in recess until council's ready.
Thank you.
Mr. Hagel. This is State of Texas versus Michael Tanner Hagel, CR 24-232. For docket call, go ahead, Mr. Schmidt.
Judge, met with Mr. Hartwell last week on Mr. Hagel, last week or recently. I made some counter offers to his offers that we're trying to get wrapped up. So I'd ask for a final docket call on Mr. Hagel.
Any objections?
No objection, Your Honor. Thank you.
All right, court sets Mr. Hagel for final docket call April 8th. 9 a.m. Or I'm sorry, 1:30 p.m. All right, so we're waiting on Mr. Morgan and then we're waiting. Correct?
Yes, sir.
Is that all we have left?
Well, we have that, Mr.
Vergara?
Yes, sir, but I didn't know how you wanted to do that one.
Have y'all had any conversations with Mr. Platt on whether he's going to zoom in for pretrial?
I haven't, Your Honor. I expect since he'll be on Zoom for Mr. Watson, maybe his intention is to do both at the same time. But
We'll just wait, Mr. Abraham, and see what he wants to do at 2:30.
Okay, and Mr. Bill is here, and so we'll get started on that plea.
Sounds good. Let me know.
All right. Your Honor.
Yes, ma'am.
Mr. Stevens is ready.
Good afternoon, Mr. Stevens. How are you, sir?
I'm good, Judge. How are you today?
Oh, I'm doing just fine.
Good.
You're here with Miss Villarreal, correct?
Yes, sir. Come on.
Miss Villarreal, come on up. This is cause numbers CR 2280 and 2022-30, State of Texas versus Alyssa Joanne Villarreal. Miss Villarreal, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Just make sure you speak up loudly and clearly for me so my court reporter can take down what you have to say. Your name is Alyssa Joanne Villarreal, is that correct?
Yes.
And Ms. Villarreal, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with Mr. Stevens as your attorney in the work he's done?
Yes, sir.
Do you understand everything that you've read and signed in your plea agreement?
Yes.
And where you have signed, you're telling the court that's your true and correct signature and you understand what you're signing.
Yes, sir.
Mr. Stevens, do you believe your client to be competent today? And if so, have you explained to her her rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor. We explained everything to her, and I do believe she's competent.
All right. Ms. Villarreal, you are charged by indictment with a state jail felony offense of possession of a controlled substance, a penalty group 1, less than 1 gram. Actually, I think that's charged by information. Is that correct, Mr. Hartwell, or is that by indictment?
Let me double check on that, Your Honor.
While Mr. Hartwell's checking on that, a state jail felony offense does carry a range of punishment if you were to be convicted and sentenced from a minimum 6 months in prison to a maximum 2 years in prison and a fine not to exceed $10,000. I see in this plea agreement, the DA's office is recommending that the court consider the evidence and that I find enough evidence to convict you, but I do not convict you today. Rather, I place you on what's known as deferred community supervision for a period of 3 years. You would also be responsible for a $1,000 fine, restitution in the amount of $180, court costs in the amount of $290, and reimbursement fees in the amount of $885. In addition, there are a couple of cases, some that have been filed, some that are not filed, that the DA's office is agreeing to dismiss and resolve with your plea agreement in this case. Those being an unfiled, unauthorized use of a vehicle, an unfiled possession of marijuana less than 2 ounces, and then a filed possession of controlled substance of penalty group 3 less than 28 grams. Those all being, well, one of those being a state jail felony, and the other 2 being misdemeanors. Ms. Villarreal, is that your understanding of the plea agreement?
Yes, sir.
All right, then did you find out, Mr. Hartwell?
Yes, Your Honor, and it was an indictment.
It's by indictment.
Yes.
Okay, so we'll need to have this front page changed.
Yes,
So
sir.
it says information. All right, so Ms. Villarreal, how do you plead to possessing a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Ms. Villarreal, have you been forced, threatened, or otherwise pressured to plead guilty to this crime?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Stevens, any objection to the admission of the stipulation of evidence?
No, Your Honor.
The stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor. Rest in place.
All right, court will consider the evidence. Right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. Court hereby defers a finding of guilt for Alyssa Joanne Villarreal on the state jail felony offense of possession of a controlled substance less than 1 gram. The court places her on 3 years community supervision, orders her to pay a $1,000 fine, $180 restitution, $290 court cost, $885 in reimbursement fees. Miss Villarreal, how old are you?
27?
27?
Yes, sir.
Are you married?
No, sir.
Do you have children?
Yes, sir.
How many kids do you have?
3.
Who's been watching your kids and taking care of them while you've been locked up?
They're in CPS right now.
They're in CPS care. Do you hope to have them back out of CPS care?
Yes, sir.
Are you going to work your service plan and do everything you can to get your children back?
They
Do you-
just,
Go ahead.
Any-
No, sir.
they
Go
just
ahead.
went to CPS like a week ago.
A week ago.
Mhm.
Do you understand that what's going to happen in CPS is you're going to be given a decision to make, and your decision is going to be, do you want drugs or do you want your children? That's it. This is as simple as it's going to be. If you choose your children, then you'll work your service plan and you'll make sure that they're not exposed to abuse or neglect and that they're provided with a safe, stable, and nurturing home. You understand that?
Yes, sir.
You understand if you pick drugs, not only will you lose your kids, but you will lose your liberty as well. Because if you violate any of the terms of these community supervision conditions, you're looking at up to a maximum 2 years in prison. And do you want to be sitting in prison while your kids are growing up?
No, sir.
Can you even stand the thought of that? Has the last all this time that they've been in CPS care and you've been locked up, has that been weighing on you?
Yes, sir.
Is it hard?
Yeah.
Well, that's good. That's a good sign. That means you love your kids. So you're given an opportunity here by the DA's office and Mr. Stevens and this court to get out and be on probation and work your service plan and do what you have to do to, one, stay out of prison, and two, to get your kids back. So you have an opportunity. Now, listen, it's going to be hard. It's not going to be easy. Don't think because you get out and you're on probation that it's going to be easy, especially if you have a drug problem. Okay. And if you have a meth problem, it's going to be very, very difficult, but it's not something that you can't overcome if you set your mind to it and that you look for resources. All right. And that you follow the advice and guidance of your probation officers and you follow your attorney's advice in your CPS case. It's something that you can do despite how difficult it may be, but you're just going to have to make a decision on what's the most important thing to you. Okay.
Yes, sir.
All right. So it's not about luck. It's about effort. It's about accountability and responsibility. All right.
Yeah.
All right. Ms. Villarreal, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Do I have dismissals on the filed case, or is that being filed downstairs with Judge Winters?
Your Honor, I believe the filed case was transferred upstairs, and I think there is a 1245 sheet with the paperwork. If not, I'll make sure that the court gets.
Do you have that, Mr. Stevens? Is there a 1245 dismissal there in your packet?
There is, Your Honor, on 2022 00030.
Okay, great. Thank you. That's what I wanted to make sure of. Okay, that'll get back over to me and I'll get that signed. All right, Ms. Villarreal, step over with the deputy. He's going to take your fingerprint.
Oh, thank you, Judge. Might be excused.
Yes, thank you, Mr. Stevens.
All right, Your Honor, we're just waiting on Mr. Morgan.
Okay, I'll tell you what we're gonna do. I'm gonna go ahead and bring Mr. Watson in. We're gonna do his plea here at the courthouse. So if you just want to turn yours off and then text me whenever you're ready. And
Okay, do you want us to bring Mr. Vergara?
yes, go ahead and bring him up. Actually, I'll tell you what, go ahead and bring Mr. Vergara up right now and
We
text me.
don't have him in here.
All right, well, text me when you do get him. I'm gonna go
Okay.
ahead and forward with Watson.
Okay.
Hold on up, Mr. Watson. And Deputy Martinez, will you go ahead and make sure that microphone's on? Yes.
These are the papers that he had in front of.
Okay. And then So I've got the copies that he signed of that actually. So where he had U mark X, kind of sort through those, make sure that you sign on those ones. Also.
Okay, so do I sign it on this one?
Yes, yeah, so you'll sign those ones. Let me get you.
Okay, yeah, sure.
May have one of you. We have a bunch of things that we.
Oh,
You want to. And Deputy Martinez, will you go ahead and move that camera closer so that Mr. Platt will be able to.
Oh. Let me go to this one.
No,
So I can hit that again.
You're good. Keep on.
Right here where it says Chris Martin, Judge presiding, do I sign that? It has an X beside it.
oh,
You're gonna sign where it says defendant or your name.
oh, yeah, so sorry, not that one.
Okay. I know how to do a thumbprint on that. Okay, so this right here.
Yes, sir.
These are all exactly the same.
Yeah. And if you want to double check. Go ahead and keep those, that'll be us.
Thanks, sir.
Thank you.
Make sure that when Mr. Platt comes on, that he's pinned. So he pops up right clicking it pin so he can see Mr.
I see him.
You see him okay?
Yeah, he's right there.
All right, good afternoon, Mr. Platt. Can you see and hear me okay?
Yes, Judge, thank you.
All right, sorry, I hear that you got the flu and under the weather.
Ugh. Not fun.
All fine. Do you see Mr. Watson here in court?
I do.
Excellent. Okay. All right. I want to go ahead and call his case. This is cause number CR 24-121, State of Texas versus Damon Scott Watson. Mr. Watson, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes,
All right.
yes, Your Honor.
Lower your hand. Your name is Damon Scott Watson, correct?
Yes, yes,
And Mr. Watson, are you a United States citizen who reads, writes, and speaks English?
yes, yes, sir.
And Mr. Watson, have you ever been diagnosed with a mental condition?
No, sir.
Okay. In this case, you're represented by your attorney, Mr. Eric Platten. Are you pleased with Mr. Platten as your attorney and the work he's done?
Yes, sir.
Do you have any questions for him or the court before we go further?
No.
And
sir.
the paperwork that you signed today, you've read over that. Mr. Platten has explained that to you, and you signed it today indicating that that's your true and correct signature and that you understand everything you signed, correct?
Yes, sir.
Okay. Mr. Platten, do you believe Mr. Watson to be competent today?
I do.
And you've explained to him his rights as they pertain to this case, correct?
Yes, Your Honor.
And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
He is.
All right, Mr. Watson, you are charged by indictment with a third-degree felony offense of obstruction or retaliation. A third-degree felony does have a range of punishment of not less than 2 years or more than 10 years confinement in prison, and also a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon you pleading guilty, the DA's office is recommending that they're agreeing that they will abandon the enhancement paragraphs in the indictment. And they're asking the court to consider the evidence, convict you of the offense, assess your sentence today at 8 years confinement in prison, but they're asking and recommending that the court suspend that 8-year sentence and place you on probation for a period of 6 years with a $2,000 fine plus court costs and reimbursement fees. And they are also agreeing to dismiss or reject an unfiled violation of a bond or protective order case with your plea in this matter to wrap up everything that you have. Is that your understanding of the plea agreement, Mr. Watson?
Yes, yes, sir.
Yours as well, Mr. Platten?
Yes, Your Honor.
All right, so Mr. Watson, then, understanding the plea agreement, understanding the range of punishment, how do you plead to obstruction or retaliation? You plead guilty?
Plead guilty.
And Mr. Watson, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, yes, sir.
And Mr. Watson, has anybody threatened you, forced you, or pressured you to plead guilty in court today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Platten, any objections to the stipulation of evidence being admitted?
No, Your Honor.
All right, the stipulation of evidence.
I have a question to Eric. Yes, sir.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. So you said that you had a question for your attorney?
Yes, yes, sir.
Uh,
It's for you too. I mean, I was just gonna ask him to kind of like get to you, you know what I mean?
Well, hang on, let's do this. How about you step out? Do you have your cell phone with you?
Yeah.
Yeah.
Well, I've already talked to him. He said it was okay. I just didn't know if I needed to say something about it.
Mr. Platt, do you know what he's gonna?
The time
Hang on.
early.
Oh, he's concerned about when the court would consider possibly a motion for early release. I explained the law to him. I think that you also had something in the paperwork about 1/3 of the time being a possibility. I think the law is 1/3 or a year, somewhere there. I said most courts like to see someone at least doing half the time, but a lot of this is dependent upon him and him completing all his conditions and having no problems on probation. While, we like that he's going into this with a good attitude to get this behind him. And if he doesn't have any problems, the court may acknowledge that down the road. But that's completely up to him at this point to not mess up and on probation. So that's what he's asking about, is whether the court might consider an early release at some point in time.
All right, thank you, Mr. Platt, and I will address that, Mr. Watson.
Yes, sir.
All right, the court having admitted the evidence and taking judicial notice of his judicial confession, is there anything further from the state?
Your Honor, state is in compliance with victim notification. We were unable to reach the victim despite multiple attempts. So short of having our investigator go through and do spending the resources on something that we would do for trial, we have made several attempts at contacting the victim in the case.
All right, thank you, Mr. Harwell. And Mr. Platt, anything further from the defense?
No, Your Honor.
And I will address Mr. Watson's question. And so Mr. Platten's statements of the law are correct. This court does consider and routinely grants early releases from community supervision when it's reported to me from the community supervision department that the defendant probationer is in strict compliance. They're not delinquent on money. They're not delinquent on classes. They're not delinquent on community supervision. If they've completed, I believe 1/3 of their sentence, they're eligible for review. The court will consider that, and oftentimes the probation department makes strong recommendations as an incentive for people that are complying with their probation to be terminated early. And so this court routinely grants early termination on probationers, defendants who have shown, have shown that they're not going to recommit crimes, that they're not having any violations, and that they're totally caught up on everything and not delinquent on anything. So-
Sure.
So when the probation department sees that and they believe that it would be in the community's best interest to have you terminated early, then they send that report over and I review it, the state reviews it, and then I make my decision.
Okay.
Right, so I do grant that quite often for people. The people that get that are the people that never show up in here on a motion to revoke, and they are always ahead of time on payments, and they're never a problem on
All right,
probation.
yes, sir. I got you.
So to what Mr. Platten said is exactly right. The ball's really in your court, and it's gonna depend on how well that you do.
Yeah, basically I can drag this out as long as I want. Pretty much what you're saying.
That, or you can get it revoked as
Yeah,
fast
that,
as,
yeah.
revoked as fast as you want. Yeah,
Yeah.
both are true.
Yeah, you know what I
Both are
mean?
true.
Yeah.
Okay, all right. So does that affect your decision whether or not you want to go forward with a plea?
No.
Okay, very well. All right, then the court is going to consider the evidence. Right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation today. The court hereby convicts Damon Scott Watson of obstruction or retaliation. A third-degree felony, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. The court finds that the state has abandoned the enhancement paragraph in the indictment. Further, the court finds that it would be in the best interest of the community for this 8-year sentence to be suspended. The court places Mr. Watson on 6 years community supervision, orders him to pay a $2,000 fine plus court costs of $290, reimbursement fees of $85. Further, the court does take into consideration and dismiss unfiled cause number DA 2022-1144, violation of bond or protective order. All right, Mr. Watson. You're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Our probation officer isn't here at the moment, but she will be after we conclude the afternoon docket. So what I'm going to ask you to do is just have a seat in the hallway. Once she gets back over here, she can go over this paperwork with you and give you information about what's next. And then if I get information that she wants you to report over to the probation department, I'll let you know. But otherwise, just sit out in the hallway and we'll be with you shortly, okay?
By the way, I live in Hawkins.
You live in Hawkins? Okay, shouldn't be a problem. Okay. If you're asking to have your probation transferred, then you'll work that out with the probation officer. Okay.
Thank you.
Okay, come on up, Mr. Watson. You gotta get fingerprinted real quick. Right, and we'll just have you have a seat in the hallway. All right, let me check, Mr. Platt, and see if we can get your other client, we'll get you out of here.
Thank you, Judge.
Ms. Tabraham, are you there? Oh, there's. So, Mr. Watson, when you're done, Mr. Crawford here with probation department, he can help you out. Do we have Mr. Vergara?
Yes, Your Honor, but I was not aware that he does not speak English.
Oh, he does not. Okay. All right, let's see. All right, Mr. Platt, and I'll give you an option here. I can reset you to Thursday. We will have to make arrangements to get an interpreter for you. You can appear via Zoom, Otherwise, I could reset you to March 25th. That'd be my next setting after Thursday.
Let me take a look here. I was going to go ahead and inform the court that I think you had a May 19th date for trial. It appears as if I have the discovery, and if I think I need a pre-trial setting, I would inform the court as such between then. But short of just, motions on punishment and in limine and stuff like that, trial motions, I'm not having an issue at this point with discovery.
Okay. What I like to do though is I like to get that, and we're on the record now, but I like to get that on the record with him. So he
Yeah.
understands that way if you're requesting to not negotiate with us. That's what it sounds like to me. You are not wanting to negotiate with the state and just want to set it for trial. Is that right?
Well, I don't want my client to think that I'm not, he speaks Spanish, and of course there's a little bit of delay and all that kind of stuff. And everybody wants their court date set. So if he knew that there was a court date set and something that was possibly coming, that might be something that he's happy about. I'm going to get over there and see him some more as soon as I can. But
Let's do this then. Let's set him on March 25th for pretrial. Okay. We'll get an interpreter here. That'll give you time to recover and that'll give you time to go see him. And on the 25th, you can make your announcements on pretrial. And if you at that time say, hey, we know that we're not going to be negotiating, and we can go ahead and set a trial date and he can get that date.
okay.
And then we can also talk about whether or not we want to specially set. I see that it is a sexual assault. We may be able to specially set it. I know our special settings are already set out through the end of the year.
Yes, Judge. There was some form of an issue with emails this morning. I don't know if it had to do with me using a VPN, but it seemed like the court was getting further emails whenever I was sending them around 11 a.m. or so. I tried to inform the court about 8:22 that I was having issues and that we would need an interpreter. So if those emails are out there, but I don't know if there was something that I noticed my VPN was on. Maybe y'all have some protecting thing in your server that doesn't want something to bounce around or come from who knows where.
Well,
But
let me ask this, and we'll go off the record for a second. Ms. Abraham, do you think that there's a possibility we could get an interpreter for like 3:00? You think if we called and see if they had any availability, or do you mean
I mean, we can see.
you mean see if Ms. Barker would mind calling and seeing if we can get somebody at 3:00 and then we could go ahead and do it today?
and if they have a Spanish speaking probation officer for the purposes of just explaining what's going on,
Well,
Or-
in order for them to be in court, they have to be licensed by the Supreme Court.
yeah,
And OCA does it. They can zoom in, but if you don't mind waiting around for 15, 20 minutes, we can
Sure.
probably find out if they have availability. If they don't, we'll just have to reset it. If
Yeah,
they do
let's-
have availability at 3 or 3:15, then we can do it.
I'll be here.
Okay, so you can do this. You can just turn your camera off and mute your mic, and then
Okay.
we'll go about trying to figure out. We've got another play to do anyway, so we can do this in the meantime.
All right. Sounds good, Judge. Thank
All right,
you.
we'll be right back with you.
All right.
Patty, do you want to call or do you mean ask Wayne's call?
I can call.
Okay, call real quick and then just text me and let me know. And if not, then we can just go back on record and reset.
Okay.
All right, thanks.
Your Honor. Mr. Smith is ready on this plea.
All right, this is cause numbers CR 24-105, CR 24-159, State of Texas versus Harold James Morgan Jr. Mr. Morgan, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you look in. All right, Mr. Morgan, your name is Harold James Morgan Jr., is that correct?
Yes, sir.
And Mr. Morgan, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any mental conditions?
No, sir.
In these cases, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes, sir.
Do you have any questions about either of your plea agreements or any of the paperwork therein?
No, sir.
And Mr. Morgan, you signed these documents today. Is that your true and correct signature that you place in these documents?
Yes.
Mr. Schmidt, do you believe Mr. Morgan to be competent today? And if so, have you explained to him his rights as they pertain to each one of these cases?
Yes, sir. I do, and I have.
Do you believe that he is entering into these agreements intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Morgan, you are charged by indictment with a first-degree felony, sexual assault, sexual abuse of a child, continuous, and also a second-degree felony offense of sexual assault. I see that the plea agreements in these cases today, cause number CR 24-105, would be you would plead guilty to the lesser included offense of sexual assault of a child, a second-degree felony, which carries a range of punishment of not less than 2 years in prison and not more than 20 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in that case is upon your plea of guilt, the state is recommending that the court assess your punishment after receiving the evidence at 18 years confinement in prison with a $100 fine for child abuse prevention. You would also be assessed court costs of $290 and reimbursement fees of $35. And that case would run concurrent or at the same time as the sentence in cause number CR 24-159. In CR 24-159, it looks like your agreement with the state is that you would plead guilty to a second-degree felony offense of sexual assault as contained in count 1 in the indictment. The state is recommending that the court assess your punishment after receiving evidence at 10 years confinement in prison, a $100 child abuse prevention fine, that your sentence in this case would also run at the same time or concurrently with the other sentence previously discussed. And in this case, the DA's office is agreeing to abandon counts 2 and count 3 in the indictment. You would also, in this case, be responsible for your court costs and reimbursement fees. In each case, you would receive 105 days credit towards each one of those sentences. Mr. Morgan, is that your understanding of the plea agreement in each case?
Yes, sir.
Yours as well, Mr. Schmidt?
That's great.
All right, so at this time, Mr. Morgan, I would ask you, how do you plead in cause number CR 24-105? How do you plead to sexual assault, a second-degree felony?
Guilty.
I guess my only question is on the first page of the judgment, it says sexual assault, but it's actually sexual assault of a child, correct?
Yes, sir.
So I think it probably needs to be reflected on, instead of just saying sexual assault, it needs to say sexual assault of a child.
Yes, sir.
I do note that the, I think the penal code section is correct. as well as the reflected age of the alleged victim.
22, 11A1.
Yes, sir.
Okay,
B.
okay. All right, so Mr. Morgan, the court would ask you at this time, how do you plead to sexual assault of a child?
Guilty.
And in cause number CR 24-159, how do you plead to sexual assault of a child as outlined in count 1?
Guilty.
Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes, sir.
And Mr. Morgan, has anybody threatened you, forced you, or pressured you to plead guilty to either crime?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence supporting the plea?
No objection.
Stipulation is admitted in each case respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the victims are supportive of this plea. And I believe protective orders were filed for the victims in these cases.
Is the civil protective order, are they part and parcel with the plea agreement?
Yes, sir, they were, and we filed those the last time, or the state filed those the last time we were going to plea. So they've been on file for a couple months at least, so we're aware of them. And that was part of the plea, yes, sir.
So no objections to the court entering a finding and ordering a protective order in each case?
Yes, no objection.
Okay,
Sorry.
it's okay. Do you all need to talk at all, Mr. Schmidt? Does he have any questions we need to address?
If I could have 30 seconds.
Sure, go ahead.
Look something up real quick. Come on. They can. Sorry, John. We're good. We're ready to proceed, Judge. Sorry about that.
Okay, no problem at all. All right, the court has admitted the stipulation of evidence in each case respectively. The court has received the statement from the state that you're in victim compliance and there's no objection and they're supportive of the plea, correct?
Yes, sir.
Mr. Schmidt, anything further from the defense?
Well, Judge. Except for that, we did receive supplemental admonishments as well as chapter 60, a copy.
Okay, very well. All right, then the court's going to review the evidence. All right, the court, having reviewed the evidence in each case, finds that each case, the evidence does substantiate the guilt of the defendant. The court will follow the plea agreement on this date and the recommendation from the state. In cause number CR 24-105, the court hereby convicts Harold James Morgan Jr. of sexual assault of a child, a second-degree felony, assesses punishment in accordance with the plea agreement at 18 years confinement. The Texas Department of Criminal Justice orders him to pay a $100 fine and orders that this case run concurrently with the sentence imposed in cause number CR 24-159. Further, the court assesses court costs of $290 and reimbursement fees of $35. The court awards Mr. Morgan 105 days credit towards his sentence for the time spent in jail on this case. In cause number CR 24-159, the court, having considered the evidence, finds that there is enough evidence to convict the defendant. The court does follow the plea agreement and recommendation from the state. Court convicts Harold James Morgan Jr. of count 1, sexual assault of a child, as indicted, assesses punishment pursuant to the plea agreement at 10 years confinement in prison. The court also orders him to pay a $100 child abuse prevention fine, orders that the sentence run concurrently with cause number CR 24-105, and the court finds that the state has abandoned counts 2 and 3 of the indictment. Further, the court assesses court costs of $290 and reimbursement fees of $35 and awards Mr. Morgan 105 days credit towards his sentence for the time that he has spent in jail on this cause. Further, the court finding that the parties have submitted an agreed protective order in civil cause numbers FM 25-00004 and FM 25-00005. The court approves those agreements and grants the protective order as requested in each case. Mr. Morgan, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
And Your Honor, I apologize. I guess is a victim impact statement.
Yeah, the court has, for the record, reviewed the victim impact statement that's been provided. I've signed that. I'm going to return it to counsel for circulation for you to sign and then circulation to the probation, sheriff's office, and district court.
Thank you, sir.
Anything further, Mr. Schmidt, on this case or any others?
Not that I'm aware of, no, sir.
Okay, thanks, sir.
Thank you.
Ms. Abraham, so Mr. Vergara, he's the only one left in the jail, correct?
Yes, Your Honor.
Okay, all right, so what we'll do is we will stand in recess. I will be watching for the interpreter to come in around 3:40. And so as soon as I see the interpreter, I'll bring him in. I'll turn my camera on, let everyone know that we can get started sooner rather than later.
Okay.
All right, we're in recess until about 3:40.
Bye.
All right, Mr. Platt, let's see, I've got my interpreter coming in. Get her set up. All right. Is it Miss Dejo? Dejo, okay, let me see. Let me set up the interpretation channel. I don't have that done quite yet. All right. Can you hear me now? Is it Deju? Okay, I'm not, for some reason, I'm not picking you up here. Let's see, I went over to the, are you in the English channel? Yeah, I'm reading your lips, but I'm not. Yes, ma'am, I can. I can hear you. Okay.
Are you able to hear her?
Well, she's in the Spanish channel right now, so only
Okay.
only your client will be able to hear her. And Mr. Platten, do you need to talk with your client in a breakout
Sí,
room thing before we get started?
If I could have a
sí,
quick
sí, lo
breakup, that'd be helpful. Just a few minutes.
Okay, so let me do this, Mr. Zhu. I'm going to go ahead and call the case and I'm going to swear you in. And then what I'm going to do is ask you to go to a breakout room with Mr. Platten and the defendant so that they can have a private conversation before we come back on. And then we'll call the case and make the official announcement, okay? But I'm going to go ahead and swear you in. If you'll go ahead and state your name and your license number for the record. All right, Ms. Deju, do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you. Okay. All right, I'm going to go ahead and send an invite to each one of you for that private room. Just accept that, and then whenever you're done, you can just exit and come back to the main session.
Thank you, Judge.
You're welcome. Stand by.
Sí,
Hello, Humberto.
ok.
Can you hear me?
Sí, sí lo escucho.
Very good. I wanted to let you know that
Eric, hang on. You're not in the breakout room yet, so you're still on YouTube and everything. So wait for just a second and you're gonna get prompted to join a room. And then when you get to that room, you'll only see your client.
yeah, I thought I was a little different this.
Yeah, just give me a second. It's gonna take just a second to set up the private room. Yes.
Normally, we're placed in a breakout room. Is that the same situation here?
Yes, sir, it is. Just give me 2 seconds. I gotta get it set up for y'all.
Sure.
You'll notice, you'll get an invite, you'll accept it, and then you'll go in there.
Right. There we go.
All right, is everyone back? Good audio, Mr. Zhu, you ready? Okay, all right. All right, this is cause number CR 24-40, State of Texas versus Humberto Vergara, and we are set for pretrial today. Mr. Platten, any announcements on pretrial?
No, no pretrial at this time, Your Honor. I would ask that the court set this off to the March 25th date, and we would know by that time if this is going to trial or not. We're thinking that the trial for the May 19th date probably would not be a bad date, or the court had stated something about maybe a special setting. I don't know.
Yeah, so the May 19th is actually a trial date for civil cases, but
Okay.
regardless, we will set Mr. Vergara for a docket call on March 25th. That will give you and Mr. Vergara an opportunity to determine whether or not you want to accept any offers being made by the state. And if there's no resolution on that date, if all of the other pretrial issues are resolved with discovery or anything like that, then you can announce on that date whether it's a bench trial or a jury trial, and we can work together on looking to see if there's a specific date that we could set for a special setting.
Sounds good, Judge.
All right. All right. Mr. Vergara, do you have any questions of Mr. Platten or anyone else before we adjourn your case?
Yeah.
Well, let's see.
He's not hearing her.
Okay, well, that's a problem. Patty, are you in the Spanish channel on the laptop?
Yes, Your Honor. Now our world's not there. Did.
And it's not there?
No, sir.
Are you still, do you see anybody on the laptop? Because I don't see that you're joined in, because I'm not seeing him on a laptop.
Maybe we're still in the.
Yeah, you got to get out of the breakout room. Well, here, let me move here. Just let me move you.
I think we're back.
All right, and then make sure that that's in the Spanish channel.
He can hear.
Okay, so let me restate what I said before. So, Mr. Platten, your announcement was that there were no contested pretrial issues at this time. You asked the court to set this on the March 25th date, which is the next available setting. And you indicated to the court that you would know by that time whether or not you were going to need a trial. And I indicated to you that we would set it for March 25th, and that would give you an opportunity to speak with the state to determine if they're making any offers that the defendant would like to accept. And if he does not, then on March 25th, we can try to set a special setting date. But that the May 19th date is actually reserved for civil cases, not criminal cases. But we would work together to find a trial date for Mr. Vergara.
Yes, Your Honor, that accurately reflects everything we discussed.
All right. And Mr. Vergara, do you have any questions, Mr. Platten, before we adjourn your hearing today? You're muted on. You can try unmuting the jail court. Did he not hear? Right.
He's in 2 rooms on my side, Your Honor. He's in jail, court, and something else.
You can
Well-
hear her in English,
Well, it's
or I
because
can.
he's on a laptop, and then there's also a webcam in there. The laptop is so that he can be unmuted and we don't create an audio loop.
Okay.
So did he not hear it? Mr. Zhu, can you ask him if he heard anything the court said?
No, no, no lo entendí.
Okay, let me repeat it again. Please, please.
Ajá. Ya ahora sí ya la escucho.
Okay. Mr. Platten announced that there were no contested pretrial issues and that he would like the court to set this next hearing on March 25th. And on that date, he indicated that he would know whether or not it needed to be set for a trial. That would give the defense and the state an opportunity to decide whether or not they're going to be able to resolve the case with a plea agreement. If not, then on March 25th, we could try to find a date to set this for trial. It would not be the May 19th date because that date is reserved for civil cases, but we could possibly set it for a special setting.
That actually reflects everything we discussed.
And so, Mr. Vergara, do you have any questions of the court or Mr. Platten before we adjourn your case?
Okay, okay, entonces dice que en el transcurso de esta fecha va a llegar a un acuerdo o algo así.
Well, what I'm saying is between today and that date is your opportunity to see if you can reach an agreement. You're not required to reach an agreement, but that would give you the opportunity to talk with the state to see what their offers may be to resolve the case. And if you want to accept that or not, if you do not, then on March 25th, you would have the right to have a trial. And on March 25th, we would set that on a specific date after March 25th to have the trial. Does that make sense?
Okay. Sí, sí, disculpe.
All right, absolutely, no problem. Okay, so Mr. Vergara, we'll see you back on March 25th, and I'll make sure that we have an interpreter lined up for your hearing again.
Thank you, Judge.
Gracias.
You're welcome. You're welcome. All right, thank you, Mr. Platten. Thank you, Mr. Zhu, for being able to hop on in such late notice. We appreciate it. We'll get it scheduled earlier next time.
Have a
Right.
good day.
Thank you. You're welcome. Have a good day. Thank you, Mr. Platten.
Okay.
All right, Ms. Abraham, anyone else at the jail?
No, sir, not to my knowledge.
Okay, all right, then that will conclude our criminal docket and we are adjourned for the day.